Good afternoon, and thank you very much for being here. The day is sunny outside. Thank you, León, for that. Thank you so much to the INCIBE and the people responsible for it for the great work and for the success of this, and for hosting this conference in this small city. That's an important step. Even when we have internet, and sometimes internet suppresses the territory, we still need to keep face-to-face encounters hosted by a territory. We'll be listening to three wonderful professionals speak about the new challenges, legal challenges, regulatory challenges that the web and cybercrime show or present. These are challenges that are generating some insecurity, but we have to know that in the history of humankind, we managed to overcome such insecurities. Let me remind you that just 1,000 years ago, no internet, the sky fell off. It didn't fall off with all the omens, but the fall of the Carolingian Empire generated a period of insecurity, and it was the peace of a monastery that developed a series of regulatory institutions. The Treaty of the Camino. These are the institutions that we have to remodel for the web to make sure that there is safety online. And I'm sure that you will enjoy the sharp comments of these great professionals. First, we will be listening to Dr. José Luis Piñar, who's a chair professor of administrative law. He will be discussing about data protection in this paradigm. We've lost our intimacy, and we have to protect our data. José Luis, you have the floor. Good afternoon, everyone. Thank you so much to the INCIBE, and in particular, thanks to Mr. Ives. It's a great pleasure for me to be here in León and to share this debate with three great friends and great professionals. Let me focus on the challenges of the regulatory framework, in particular, as Mercedes said, in personal data, protection of personal data. And let me discuss something that's quite new, which is the approval a year ago of the European Data Protection Act. And we all know this is commonplace, but we need to repeat it, that will be implemented in full on the 28th of May, 2018. Many things will change after that, and within the regulatory framework, we'll see a change in the fact that there will be a new model of privacy or data protection in Europe. And I say in the world, because the European regulation is going to, through their implementation, extraterritorial implementation to multinationals, they process millions of data. Article 3 states that everybody who is working with personal data outside the European Union, but the recipients are in the EU, they'll have to follow this. So it's a worldwide regulation. So this new model is an Anglo-Saxon model. We'll have to get used to it. And that's something that I was discussing before the session during lunch. This is a model based on proactive responsibility. So against the situation we have now, which those who work in data protection know what they have to do because there is a standard, the regulation of 2007 and the Spanish Act. This is a bureaucratic approach, if you allow me to say it this way. From data management, we are going to speak about the governability of information, and we'll have to make the necessary measures to comply with the regulation and to prove that we do. Let me use a very simple example. I apologize for such a simple example, even a childish example, but this may help us understand what is coming towards us. So now we're driving on the highway, and we know the speed limit. And if I'm not going as fast as 120, for example, for a highway, they cannot fine me if I drive slower than 120, which is the maximum limit. But with a new regulation, this sign will say, please drive according to the adequate speed. It's me who has to determine, and the police can stop me and they will say, no, you're driving at 90 kilometers per hour and you should be driving at another speed. And you could go at 120, 110. But you have to look at the risk, and that's really important for this new model. So everyone has to determine what they're going to do with the data. Of course, the regulation, it has 20 articles. It's very detailed in many aspects. Express, follow-up, or the legitimate follow-up. But in many cases, they leave it open for the person responsible to decide. Somebody was saying that those who are responsible, the officers, they stop being minors. They have to decide for themselves. But of course, for those of us who are used to having regulations and in the continental view, we'll see that this is a radical change because it's going towards self-regulation. And we have principles such as privacy by default, by design, so that we'll have to have the pertinent measures. But this is not just to comply. This is the Article 24 of the regulation, but to prove that we are complying, and against whom, and to prove it in front of whom? The data authority. So the model has changed in the regulatory framework of data protection. We really need to think about this. And that's it. That's what I wanted to share so far. And I wanted to leave you with this message before we start the discussion. Okay, so let us now give the floor to Lisa Tejada. And we thank you for your work as a public attorney. And how about the safety of the web from your perspective? Good afternoon. It's a great pleasure for me to be here with friends. I think that one of the most important topics we're facing right now, and we have two international organizations working on this, is how we work, how we cooperate between the private and public sector when we're trying to guarantee safety in cyberspace, and how we can prevent computer attacks and to minimize the effect of these attacks. So there's no surprise in our being concerned about this, because the networks are in private hands, and they therefore belong to the private sector, and is the same for many organizations or institutions that deliver primary sectors, even critical infrastructure like transportation, energy, electricity. They're in private hands. All these services are delivered with complex computer support, and that's what guarantees that the services are going to be delivered properly. But the capacity that these technological tools have to deliver services properly can become a risk element, a risk factor, because those technological tools, when they are not properly used, can generate disturbances, serious disturbances in service delivery. This is a topic that at European level, Directive 40 of 2013 at least I heard it being mentioned several times, and they already mentioned attacks. It already mentioned attacks to IT systems. In the directive, they had two viewpoints: preventive measures and the response of the rule of law to this. That is the power that the state may have, the repression from the state to sanction and label as crimes the attacks when they need to be considered as such. So if we can forget about this for a minute, we really need to think about prevention now that the directive included the several aspects, and they were deeply developed by the 1148 directive, the ENISE directive. We're all familiar with it, and we've discussed this several times. And in a nutshell, this is just a set of measures to protect networks and systems. In the NIS directive, we have several action lines. They're all very interesting. But of course, they've been discussed in different forums. For example, that all states have a national cybersecurity strategy, that there is a network at European level of certs, that they share information regarding different incidents. But I'd like to highlight a particular aspect, which are the duties generated for essential operators and for service providers, digital service providers. The director defines what essential operators are. That is, those who are working in the field of strategic sectors. This morning, by the end of the session, we had Endesa, Metro Madrid. So these kinds of providers, that is, actors who belong to the private sector but who are working on areas that have to do with service delivery of essential services. And they have two types of duties, these service providers. First, that they need to have some safety measures to avoid or to hinder IT attacks or minimize their effects. And a second one where I would like to focus, which is the notification of incidents that they have in their networks and that are relevant. I'm not going to discuss when they are relevant or not. That's something that the law does. But I'd like to highlight this because the objective is that things are known, that these incidents are known, and that different national and international organizations or from other countries can lift the safety barriers. But there's another important consequence, and I'd like to highlight this, and is that adequate notification of these incidents may facilitate a criminal action from the rule of law against those incidents that are crimes. Because I said that the directive of 2013 emphasized this aspect, and it gives you a series of crimes. So it specifies some crimes in the field of IT attacks. And the directive is based on the Budapest Declaration of the Council of Europe that lists the same kinds of crimes. And we need to think about this because when we speak about the Council of Europe, we're not just speaking about the EU, we're speaking about a larger implementation area or jurisdiction. And this involves not just those in the Council of Europe, but also third countries as well. And they are important in this, such as Israel, the US, Japan, or Canada. So there's an effort in terms of standardizing the legislation so that all countries have a list of crimes for the same kind of IT attacks and to work in the same way and go against those attacks. So these crimes have been included in our criminal code in Spain. And if we look at this new reform, nowadays in Spain, there are crimes such as, for example, unlawful access to IT systems against security measures. It is a crime as well if you're not authorized to intercept communications between systems to capture information. It is also a crime to intercept information through electromagnetic pathways, attacking data or systems, data programs, and e-documents. And another crime is to hinder the operations of a computer system. And also, it's also a crime that you prepare those tools, so preparatory acts to manufacture, import, having, or selling, or providing to others the tools to conduct such attacks. This is what we have in Spain. We can prosecute this, and we can judge this and fine or punish. The thing is that we have very few cases of this kind. They're negligible. I could give you some data of last year's records. For example, attacks related to espionage is just 500, and computer damage as such 114. So that is the exact figure. These are negligible figures against the number, because this is published by official institutions, of security incidents happening. What happens then? Are they not? They're not being. There are no complaints. Why aren't they? I don't know, but I can imagine. Sometimes due to reputational issues, some other times because people do not know that they have to file a complaint. And I'd like to say that there's a legal duty of all affecting all citizens and public authorities of presenting a complaint if they know of any crime. So there's a duty to file a complaint, and this is not happening. And I'd like to go back to what I said before. This legal duty included in the ENISE directive, and Spain will have to follow that, of notifying incidents, security incidents, I think is going to have a positive effect on this. Because I think that through this line, we will have new complaints reaching law enforcement and the justice system. And we'll have many of these incidents coming to us. Of course, not all incidents are crimes, but a large share of them are. So I'll just like to finish with two reflections about all this. First, I think this is a positive move. I'd like to say again that there's a duty to file a complaint. This was there before the ENISE directive, but as this is not working, the ENISE directive is an indirect way to make things easier, to have this information reaching those who have to prosecute. And I think that this is good, that we need to prosecute against these acts. They have to be prosecuted through a criminal code. And this is due to two things. I've said it before, because we have to break the feeling of impunity. We have to stop impunity on the web. Criminals should not think that this is something that has no repercussion, and we need to act against that. We need to prosecute those responsible for those acts and punish them. And I think that this is closing the circle. We complement prevention because we need to have preventive measures, but then the state can show that those who do not follow the rules are going to be punished. And then a second suggestion I'd like to share with you, or the second reflection rather, that I wanted to share with you related to this legal duty of informing about any incident, is that this is a challenge for all of us. We have the tools, we will have a notification of the events, and we have to make this work. We have to make sure that we convey the information properly, that we move the information from critical and essential operators to the national authority who has to receive this notification, and from there to the bodies that are responsible for prosecution in the legal setting. We need to have good coordination mechanisms so that the information flows and so that we can do our job. In that sense, to conclude, I'd say that the Public Prosecutor's Office wanted to contribute to this, and we have just published the letter 3/2017. I said 2015, sorry. It's this 2017, in which we go into the details of these crimes so that not just people in the legal setting, but others, laymen and women, so that they can understand whenever there's an incident which types are crimes and which aren't. So in a nutshell, this is something that we all have to do. This is a chain, and we all play a role in it. So we all have to play a role, and the Public Prosecutor's Office is ready to play theirs. Thank you. Thank you very much, Elisa, for your great description and contribution. So we will read that letter, that newsletter that you sent. Now we will be listening to Jorge Villarino, who is active in many spheres, but he is now working for INCIBE. And he will be discussing what we should expect. We have colleagues of mine who are also working in the sphere, and they're working with robots, and they may be helpful. Thank you very much to the INCIBE for their invitation. Thank you for having me here at this round table with such great speakers, and thank you all for being here. I have to confess that I can't see you very well because we have the lights on stage and I can't see you all, but I feel your presence over there. I had a presentation. If it's not working, it's okay, but I had given it to the technicians. Can we have my presentation? Otherwise, I'll start because we should not waste time. I'd like to try and respond or share some reflections on 5 issues. First, should we regulate the web? This may look like, okay, yeah, that's my presentation. Should we regulate the web? Can we regulate the web? What problems do we have to do that? What challenges are ahead of us? And how do I think that we should regulate the web? The first thing may be obvious, but 20 years ago, this was a question, a real question. The cyber anarchist movement, what was the name they had then, including relevant members, claimed that internet should not be regulated. This guy is John P. Barlow, the founder of an institution which in 1986 declared in the independence of the cyberspace, and he said, governments of the world, you have nothing to say here, leave us alone. This was a statement that was made, and in some fields this still exists. But the fact is that the web has been regulated in different areas. We have examples. José was mentioning the Data Protection Act and also positive developments, for example, in the parliament in Spain about social media, Obama's order about neutrality online, or the Budapest Convention for Cybercrime. So the fact is that public authorities, in their own way, are trying to regulate aspects of the web. But they have to face the problems, and the most important problem is due to the essence of the web itself. And basically, this relates to 3 aspects. First, speed, the speed in which new technologies develop. When you're working on something, there's something new the next day. All of you working in cybersecurity, you know about this. You know this. Borderlessness, Elvira knows about this well. This is a challenge, as there are no borders, especially for cyber criminals. And thirdly, the fact that internet is seen as a space for freedom. It's in its essence. When I was speaking about freedom, Thomas Watson, an IBM president in 1948, said that he estimated in the world there was a market for 5 computers. He was working with the idea of a mainframe. This is one of the reference machines nowadays in artificial intelligence, and it's called IBM Watson for a reason. So this is just to show the speed at which we're moving. Then the borderlessness of internet, as I said before, this is something that benefits the bad guys. And thirdly, that internet is freedom. was a professor of Temple University, David Post. I'd like to invite you to read it. It was something like searching for Jefferson's muse, and it translated the political philosophy of Thomas Jefferson to internet. And it was one of the best definitions of internet, according to me, to understand the end-to-end principle. He says that in the web is a stupid web to which intelligent machines get connected to. That's the essence of the internet. So this is all very difficult for public authorities and for states, which was until recently those who had the monopoly of setting standards. We have the law as a tool to do that. And this is difficult due to 3 reasons. First, the state is very slow in regulating. This is a fact. It's terribly slow. José was mentioning the General Act for Data Protection. The first commission was in 2012 and is going to be applicable in 2018. Secondly, because states have borders. And this is something that still works this way. But at the same time, the state cannot allow everything. We cannot allow this total freedom online. And out of these 3 features, that's what criminals, cyber criminals, make the best of in order to look for impunity. I don't think there's impunity, as you were saying, but traditional instruments have to face lots of difficulties. Let us look at some of the challenges. As Mercedes was saying, some of the colleagues here, they know about this. I've just included a list of them. Blockchain is about reliability to the N factor. We will not know whether this is true. Then the second example is artificial intelligence, AlphaGo, or autonomous cars. There's a diagram of Werner's consultancy, which is a reputed consultancy regarding technological development. And they go from cognitive computation to deep learning, many things, many challenges that are frightening and really frightening. And those of us in our firm, we work in the private sphere, but also in the public sphere, and public authorities are frightened because they have 2 factors. First, they do not have the technical knowledge, and secondly, they are overwhelmed by the speed of things. Internet is a revolution of revolutions. In the history of humankind, there were several revolutions, but the history of humankind is now in a continuous revolution. But there are challenges that are here to stay, and there's still challenges. There are old challenges in internet. I'm speaking about collaborative economies, social media, freedom of expression. We were speaking before about the terrible things that you can say online on social media. And we're speaking about copyright law. These are all challenges, but they're still there, and these are not solved yet. So 4 lines about how we can face the difficulties that we have to regulate. Elvira has just mentioned this. First, we need to have more public-private cooperation. Ladies and gentlemen, the good guys are more than the bad guys in society. So private-public cooperation is of essence. Elvira was mentioning some examples, and there are companies that have gone through this meeting, and they have shown the public-private cooperation, because this is something for the general interest and for all of us. Then José Luis has also mentioned this. This is also in the Data Protection Act, but this is an example that can be taken to other spheres. That is the principle of active responsibility and self-regulation. Many times in many acts, they speak about self-regulation as a mechanism, but this is not used, and we have to foster this. And big internet giants have to help us in self-regulation. And then, of course, the surveillance action of public authorities. We cannot regulate everything, but we have to survey everything. We need to think about the resources we have, and I'm sure that everybody will agree with me in this. Cybersecurity demands a lot of resources, of public resources, and we need to invest money there. I know this is a cliche, but I believe this. We need to have education, awareness. Let me share a personal anecdote. My daughter is 9 months old. I give her a toy mobile and she throws it away. But if I give her mine, she's like crazy for 20 minutes. I do not understand why, but this is a fact. And finally, and I think that Elvira is going to agree with me, we need to make international cooperation faster. Of course, we need to have these mutual cooperation agreements and the tools that we have for spaces such as the European Union. But we really need to look, without losing any legal guarantee, we need to be as fast as possible. Otherwise, we cannot fight against cyber criminals. And that's it. Thank you very much for your attention. Okay, I'm not sure whether we will have any questions, but in the meantime, yes, there is a question there. The chair, but if maybe you could introduce yourselves before you ask the question. We're sorry, but if the speakers don't use the microphone, we cannot translate or interpret. Okay, my name is Bernardo. I work in a consultancy firm, and I'm a cyber anarchist in 80% of my thoughts. Let's go back to the 20% for the cases where I think there should be regulations such as crimes, for example, pedophilia and such things that should not be on any space. But I think that it's great to see the public prosecutor's office present here. And this is a question that I'd like to address to her. Sometimes we see that there's a lot of scapegoating. Internet cannot be regulated, at least in an easy way, and not even the governments of China and Korea, who have a strong regulation, can manage to do this to 100%. And sometimes we're just looking for scapegoats who can be found. And this is just there's a case now, for example, of a kid, I'm not sure whether, I think he's underage, who brought down a page with an automated tool. He clicked on a tool, the tool crashed the website, and now there's a criminal liability. So I think that on the one hand, we're telling people if you cannot do all this and all that, and then this will stop kids from being professionals in cybersecurity, help us in all of these challenges. And on the other hand, I think that the state is trying to look for scapegoats and showing to some extent the power that it has, but at the same time, this is being done from a very fleeting fashion, because those who really harm cannot be caught easily. Yes, I'll have to know first the specific case, because speaking in abstract terms is a bit difficult. The crimes that have been listed for cyber attacks, because I think that's what you're referring to, they are measured. They demand that there is an outcome and that the outcome is serious. So with that, I mean to say that if it is an irrelevant or negligible attack, it's not usually there to be likely to be prosecuted or to be considered a crime. Secondly, for all crimes, be it pornography or attacks or hate crime through internet, we also consider the damage, the intention to cause damage. Of course, we can make if it is a matter of a mistake, I would be surprised if there is any legal liability if there was no intention to cause damage, because this is not even there for accidental damage. So we would have to see the concrete example, because sometimes we hear, oh, there's a criminal liability, and that was a minor thing. We would have to see for each case whether this is a minor thing or not. So you have to realize that the response that criminal law provides is the last response of the rule of law. This is what is applied last for serious acts, and it is measured, and we try to see that this is a serious act. But you're right about something that you are mentioning, that we only catch those who are close to us. For example, if we only get to the last person, even if it is, or the person who is organizing this, who's organizing a fraud chain from the Ukraine, we cannot get there. But this happens with all sorts of criminal networks, physical or online. We try to come as far as we can, but sometimes we cannot come to the head. But we still have to demand liability to the intermediate and lower ranks. Obviously, the response of criminal law is not the same when we go against the organizer, and I wish we could always go against the organizer, when we go to the last link in the chain. And this goes back to what Jorge was saying. I think that in this field, the most important challenge is international cooperation. And the legal harmonization we were discussing is going in this line, trying to get to the heads of big criminal organizations that are beyond our borders, and they are not being prosecuted. Thank you. Just a comment, because I am a chair, but I would like to intervene. When we're speaking about prevention, I agree with you, and I have my studies about this. I think that we have the freedom of the seas now and internet and the Salamanca School, and the neutrality and equality of the web, so that, as you say, all these young people can help, because that's how this started and developed. So in this sense, I would like to ask for your cooperation as good professionals and experts. This is not a cliche. This is something that has to do with education. That's where the hot potato is. We are saying we should not have borders from the EU. We always speak about the rights and duties, and those are the stars and the EU flag. We have to educate so that this kid can continue working, but not in the field of crime or hate crime. So that is maybe my utopian view of education. A microphone?
Muchas gracias. Bueno, me han parecido interesantísimas sus aportaciones. Vamos.
These have been very interesting contributions. So I have the feeling the world of data protection and privacy goes on one side, the world of what is understood, or the need to they have to be effective, and the world of the ENISE directive that goes a different way. There seems to be some agreement in the field of data protection. There were some sanctions, which is an interesting way of doing about those who dealing with those who do not comply. Once the ENISE directive is transposed, there will be sanctions, precisely for one of the things that you mentioned, Elvira. The reporting, the notification. You have to report incidents. Most incidents, in the case of an attack, are multidimensional. On the one hand, these are presumably criminal behaviors, but they also go beyond the data protection laws. And I'm under the impression that both legislations go each one on their own side. Do you think there is a chance of coordinating them? Then there is, with regards to the personal data protection, there seems to be some lack of defense due to the Anglo-Saxon model. The truth about risk analysis obviously to protect assets and so forth, but as a function of the state of the art of technology. And this leaves us all, in a way, defenseless in the case of being the target or the object of a sanction, or both. It's true. Perhaps there are some disagreement between the regulation and the ENISE directive, especially that with regards to reporting security incidents. I'll refer to a specific point. The ENISE directive regulates this for telecoms, not so for the case of data protection. It is now brought into the regulation. However, one thing is to report incidents, another thing to report violations. So what happens when there is a violation at the same time of the directive and of the regulation? The directive, I'm concerned, when one of the articles of the directive says expressly that the report will not lead to further actions. However, the whereas clause of the 87 of the regulation says that reporting is without prejudice to any further actions that may be carried around. And this entails a series of self-blaming or self-inculpation when you are notifying a security breach or incident, or what goes in the law. What the agency is pointing out is that there will be no action when there's no negligence behind the breach. So one thing is for a burglar to break into your home, and another thing is for me to leave the door open and someone comes in. I think that's more or less the philosophy. But you're absolutely right in that perhaps there are some elements that should be rediscussed. This leads me to the following. When we are reflecting on this, and Jorge was clear about it, concerning whether the right is at the level of, whether the law is at the level of technological developments, I think that we have to identify the essential elements that operate the same for the ENISE directive and for the regulation, and anything that has to do with technological innovation. There are always disruptive situations. This is nothing new. The French Revolution was the disruption per se, the discovery of the Americas, but there's something different now. But the law has always been capable of facing disruptive situations based on principles. What we cannot have is a specific standard for a specific case that is obsolete immediately. You have self-regulation, as Jorge said, and we have to define this right in a different way. So through principles, perhaps self-regulation, we may adapt to specific situations. We have 10 seconds. The progress clause for all such indefinitions. We have seen for many years how this clause has been implemented. The techniques are there, you have to study them, and we have to have good interlocutors like yourself. Thank you very much. Thank you very much.